2023 Maricopa County Board of Adjustment to order. Rosalie, would you please take a roll call vote?
Chairman Loper,
Here.
Vice Chairperson, Member Ward,
Here.
Member Cardin,
Here.
Member Clapp. Chairman, we have a quorum.
Thank you very much. Move on to the announcements. This meeting has been noticed in accordance with the open meeting laws of ARS 38-431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office and are also available on the Planning and Development website 1 week prior to hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony in a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card if you're here in attendance. Rosalie's got those, and so if you want to speak, make sure you fill that out and hand one to Rosalie. Or registering a desire to comment as noted on the published agenda. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. Staff will provide the chair with the names of persons who have registered and noted a desire to comment, and those registered participants who have raised their hand. Chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed for testimony shall be at the discretion of the board chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chair regarding public comment. Votes will be done by roll call vote only, and the chair will verbally identify the specific members responsible for all motions and seconds. Move on to, no minutes, it's time to the consent agenda. Staff?
Yes, Mr. Chairman, board members, there are 2 items on consent. They are BA 2023-018, known as Sweet Home Investing LLC in District 4. It's a variance to the southwest rear setback against the 65 LDN noise contour, which forms the MAA-MF overlay zoning district boundary line. For a 2-acre property at 23016 West Parkview Road, there's no known opposition. In paragraph 16, the findings are that it meets the statutory test for approval, memorialized by item A. And then BA 2023-031, known as Augusta Investments Property in District 4. It's a variance to the north side setback for approximate 1-acre property at 29218 North 254th Avenue. Again, no known opposition. And in paragraph 19, the findings are that it meets the statutory test for approval subject to item A. Happy to answer any questions.
Thank you. Any questions of staff on the consent agenda items? All right, if none, I'm entertain a motion.
I'll move that we approve the consent agenda items.
All right, we have a motion for approval by member Cardin. Is there a second?
Second.
We have a second by member Ward. Rosalie, if you please take the roll call vote.
Member Cardin,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 3-0.
Congratulations to those approved on the consent agenda. And also I'll note that board member Clapp has just walked in and is joining us as part of this hearing. No worries. I almost was as well. All right, move on to the agenda, regular agenda. First item is BA 2023-019, the Freeman property. Mr. Mueller.
Thank you, Chairman and members of the board. Case BA 2023-019 is for the Freeman property located in District 1. It is at 24025 North 87th Avenue in the Peoria area. It is for a proposed lot width of 107 feet, where 120 feet is the required. The subject property appears to have been created sometime in 1986 in a minor land division that split the property from the lot due south. This filed an approved zone change request in that same year that changed the zoning of the subject parcel and the parcel to the south to R118 from row 43. The required 120-foot lot width would have been the same at the time the existing single-family residence was constructed, which first appears in aerials around 1987. Next slide, please. The applicant is now seeking the variance in order to obtain zoning clearance on a building permit for an accessory structure. The structure meets all setbacks and only needs relief from the non-conforming lot width. Next slide, please. With that said, staff has found that while the parcel has existed in its current configuration for almost 40 years, there is no peculiar condition facing the property, creating a hardship in that the property is relatively flat and that the non-conforming lot width appears to be the result of an unregulated lot split. The applicant has failed to demonstrate that the peculiar condition is not self-created in the line of title because the lot existed in the current configuration, albeit with an existing residence prior to the current owner taking possession of the property. If the board finds that the applicant has proven entitlement to the variance, staff offers the following to memorialize the approval. Variance approval establishes a 107-foot lot width for APN 201-15134. At this time, I'd be happy to answer any questions you may have.
Thank you, Joe. Great presentation. Are there any questions of staff at this time by any board member? All right, seeing none, I'll open the public hearing. Is the applicant or applicant's representative in attendance? Come on up if you could, please. Provide your name for the record. And when you're finished speaking, fill out one of the speaker request cards, please. Oh, you never mind about the speaker card. She doesn't need it for the applicant. Okay.
Good morning, everybody. My name is Keith Freeman. I'm the one that resides at this property. Thanks, everybody, for their time. We bought our property in 1991 and had no idea that zoning 30 years later would hurt us building a steel structure. We're now ready to retire and plan to build at the back of our property. We did our due diligence, at least I thought, by going to the zoning committee or the zoning office and getting the zoning zones. 30% of the backyard, 10 feet off the back, 3 feet, 10 feet off the back of the house, 10 feet from the back, and 3 feet off the side. So once we did that, I ordered the steel building. I thought we were good. Now I have the materials for the steel building in my backyard to find out that I don't know when this happened originally or whatever, but I need some help here. That's pretty much it. I thank everybody for their time.
Thank you very much. Are there any questions of the applicant by any of the board members? All right, hold tight. We may have something for you.
Yes, sir.
We have no speaker request cards. Is there anyone in the audience who wishes to speak on this matter? Nobody in the audience. David, is there anyone online? No one online as well. We'll go ahead and close the public hearing and turn it over to the board for discussion and or a motion. I'm just going to add personally, arguable about whether or not you should have known when you purchased this, but I've always been of the opinion that these undersized lots, it's better if they're utilized than if they just sit vacant. And part of that is the ability, what you're requesting otherwise meets zoning development standards. And I personally have no issue with this. Any other board members wish to make a motion? Member Cardin.
I move that we approve BA 2023-019.
We have a motion for approval by member Cardin. Is there a second?
Second.
Tie goes to the runner. Member Clapp beat you, Fern, by just that much. That was second by member Clapp. Rosalie, if you please do roll call.
Member Cardin,
Yes.
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper,
Yes.
Chairman, that's an approval by a vote of 4-0.
Congratulations.
Thank you.
Move on to the next agenda item, item number 4, which is BA 2023-026 Gardens of Sun City. Turn this over to staff.
I can't hear anything, just
Sorry
if
about
someone's
that.
speaking. Oh, sorry.
Agenda item number 4, subject to case EA 2023-026, is a variance request for R3 zone property located at 17-25 North Boswell Boulevard in the Sun City area in Supervisor District 4. The variance request is for a proposed sign setback of 0 feet where 20 feet is the minimum permitted on the west portion of the parcel. The applicant is proposing on removing the existing sign and placing a new sign closer to Boswell Drive in order to be more visible from the right-of-way. Next slide, please. Staff notes that there is an option to locate the sign within the private driveway median tract, maintaining the required 20-foot front yard setback. Staff recommends denial of BA 2023-026 as the applicant has failed to demonstrate that the strict application of the Maricopa County Zoning Ordinance to the subject property has caused undue to physical hardship that prevents the reasonable further development of the property. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state on the record for the basis of that determination with findings and conclusion in a motion to grant the request. At this time, I am happy to answer any questions. Thank you.
Thank you, Ms. Aramillo. Are there any questions of staff on this case at this time? Seeing none, go ahead and open the public hearing. Is the applicant or applicant's representative here? You could come up and provide your name for the record and go ahead with your presentation.
My name is Yusuf, representing the client. We're the architect Cunningham, and the client have suffered hardship by.
Can you move that up a little? The whole podium, there's a button that I think that moves it up. It's an issue like this that costs somebody a run for the presidency. Dating myself. Go ahead. Sorry.
So the location, the current location of this.
If you could start over again with your name, just make sure.
My name is Yusuf Metta with Cunningham. We're the architect representing the client of Sun City, the Gardens of Sun City. The current location of the signage is causing the property and the community a lot of hardship. There is a neighboring community that's a senior living, and each time either staff, new staff, or potential resident would come, they land the first one because the other one is set back and is not seen. So we would appreciate looking into that.
Thank you. Are there any questions of the applicant? Any board members? Go ahead, Member Clapp.
Just one question. The staff has recommended that the sign be placed in the driveway median. What's your opinion of that, or will that work?
Yeah, I think that's a great idea. The only thing we're just running into right now is that this island, if you don't mind just going to page 4. The picture of there is currently palm trees on this aisle. So if we were to place that, we'll have to take those palm trees out. So I think the original location might be just better for the sake of saving the trees, but we're open to the options.
Thank you.
Thank you. Any other questions of the applicant at this time? All right, seeing none, if you could hang tight, we might have some other stuff for you. This is a public hearing. Is there anyone in the audience who wishes to speak on this matter? Seeing none, is there anyone online? No one online. Thank you, David. All right, I'll go ahead and close the public hearing. and turn this over to board members for discussion and or a motion. A couple of comments I have. I'm very appreciative of staff coming up with what I thought was a really, really good solution for this. But I also get trying to save the trees. And I maybe it's because I'm getting older and I need these more and more, but good signage I find plays a bigger and bigger role in my finding things for the first time. The apps are great, but nothing like being able to see it in person. I support the request personally. Anybody else have any comments or? Seeing none, I do have a question. Staff just confirmed. Is their proposed location? It's not in a vision triangle, is it?
I don't believe it is in the engineered site distance line.
Right, good deal. All right, again, anybody wishing to make a motion? District 4, which is my district, but go ahead, Member Cardin.
I'd move that we approve BA 2023-026.
Have a motion for approval by Member Cardin. Is there a second?
Second.
We have a second by Member Ward. Rosalie, would you please take a roll call?
Member Cardin,
Yes.
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes,
Chairman, that's an approval by a vote of 4-0.
congratulations. Move on to the next item on the agenda, BA 2023-030, the Mercado property. Mr. Schlimm.
Thank you, Chairman Loper and members of the board. Case BA 2023-030 is a request to reduce the rear yard setback on their Mercado property to 17 feet, where 25 feet is the minimum required. Next slide, please. So the property is located at 25826 North Lago Lane on lot 79 of the Rio Verde Unit 2 subdivision. This is an R18 parcel featuring a single-family residence originally built in 1984. Next slide, please. So the property owners are proposing to build a 400 square foot 2-car garage on the south side of the existing residence. There is already an existing garage attached to the home. The local HOA is not allowing the owner's children to keep their 2 vehicles parked in the driveway for an extended period of time, hence their proposal for a second garage. As you can see in the site plan, this new garage would encroach 8 feet into the required rear yard of the property. The owners had originally proposed to build a detached garage, which would have been allowed per MCZO Article 1106.2. However, the HOA will not allow a detached garage per community CC&Rs. So the HOA is stipulating their approval on connecting the garage to the primary residence by way of a pergola, effectively rendering it an attached structure. To accommodate the new garage, a setback variance would be required as the garage would not otherwise fit within the lot's building envelope. Next slide, please. So you can see here some photographs as well as some additional elevations. Next slide, please. So driveway access to the home from Lago Lane is along the northwest side lot line, and due to the unusual orientation of the driveway and residence, the entrance to the existing garage faces toward the west corner of the lot where the side yard and rear yard intersect. For this reason, any additional garage would need to be located toward the rear of the lot. Now, theoretically, if the entrance to the existing garage faced toward the north instead of the west, there would be sufficient room for an additional 20-foot by 20-foot garage without encroaching on setbacks. But given the actual conditions, finding a suitable location for the new garage entirely within the building envelope without blocking the existing garage entrance becomes much more difficult. Measurements made on the site plan suggest it could be done, but it would require removing a portion of the home's existing balcony. Understandably, to avoid excessive alterations to the residence and to adhere to HOA requirements, the owners want to reduce the rear setback. However, staff notes that HOA regulations do not create an undue physical hardship. If not for the HOA requirements, physical development of a detached garage would be completely feasible. In fact, without the pergola, the garage as proposed would be a detached structure and thus a variance would not be necessary. Furthermore, the peculiar condition created by the orientation of the residence and existing garage is self-created in the line of title, as the residence was developed in this manner by then owners in 1984. Staff notes that no public comment has been received on the request. And based upon what the applicant has submitted in the staff analysis, staff finds that the request fails to meet the statutory test for variance approval. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination with findings and conclusion in a motion to grant the relief sought. In such event, staff would offer the following to memorialize the variance approval. Variance approval establishes a 17-foot south setback line for APN 219-43627. And at this time, I'd be happy to answer any questions. Thank you.
Thank you very much for presentation. Are there any questions of staff at this time? Seeing none, but I do want to confirm one of the statements. But for the breezeway, the HOA request, they wouldn't need a variance.
Chairman Loper, that is correct. The fact of the matter is, if it were a detached structure without the pergola, or it would be a detached structure without the pergola, and detached accessory structures are allowed in the required rear or side yard so long as they don't take up more than 30% of that yard and they don't come nearer than 3 feet to the lot line.
And does the pergola itself require any kind of inspection or permit from the county if it's under, what is it, 200 square feet?
Mr. Chairman, it's attached, so there would be a permit. It's not a separate structure since it's attached. It's an addition.
Okay. Oh, I get that. Thank you for clarifying that for me. All right. Go ahead and open the public hearing. Is there anyone in the audience who wishes to speak on this matter? The applicant or applicant's representative? Come on up, please. Provide your name for the record and go forward with your presentation.
Good morning, Chairman, Vice Chairman, board members, and staff. My name is John Escalera, John Escalera Designs. Thank you in advance for your consideration on this project. In 1981, a developer made the decision to develop this unique lot. As you can see, it is in odd shape and has topographic challenges as well. 42 years ago, the typical family dynamics were quite different. Families had fewer adult children living with them and fewer vehicles. Therefore, a two-car garage was the norm. In the event that a family had more than 2 cars, they simply just parked in the driveway. That's not an option in our community, unfortunately. I believe there is definitely a hardship developing this lot to provide 2 additional covered parking spaces. With all due respect to the staff's alternative suggestions, they are not feasible. The logistics of redesigning the existing garage is cost prohibitive and very challenging structurally. To move the garage door to the north face, we'd have to completely tear out the existing garage slab, create a new opening, compromising the lateral stability and structural stability, and re-pour that slab with the slope, 2-inch slope towards the threshold, and extensive excavation of probably 6 to 8 feet of dirt to accommodate the scheme that they proposed. Additionally, the HOA, we've been down the road with them. This is what they would approve. We're thankful that they allowed us to encroach in the setback, but their caveat was it has to be attached with the pergola. We respectfully request that you approve our variance for the submitted plans. We are preserving the intent of Chapter 11, Article 1106.2, other than the fact that we are attached with 80 square inches of pergola. That's less than 1 square foot of actual physical attachment. We are 17 feet from the property line, and there are no neighbors to the south, only the golf course fairway. The nearest structure to the south is approximately 350 feet. And the only interaction with the public is if somebody slices on that fairway and comes near our property. If there are any questions that you have, I'll take them whenever you're ready. Thank you again.
Thank you. Are there any questions of the applicant? Member Clapp?
Just one question. Do you own the driveway? Is that your land?
That's not my land. I'm the architect.
No, I'm sorry. Does the applicant own the driveway? So the HOA has the CC&R saying that you can't use a driveway even though it's their land.
Correct. And it's a sloping driveway. There's like a 6 to 8 foot grade differential. They're basically in a bowl.
Yeah.
So you can't really park on the sloping portion of the driveway. They won't let you anyhow.
Yeah. Okay. I got it. Thank you.
Thank you. Are there any other questions of the applicant? All right, this is a public hearing. Hang tight. We may have something else for you. Is there anyone in the audience who wishes to speak on this matter? David, do we have no one online as well? Okay, I'll go ahead and close the public hearing. Turn this over to the board for discussion and or a motion.
I think you're in a pickle. That you are dictated what you can do by the HOA. Luckily, they have allowed you to come up with this accommodation of adding a pergola to make it an attached garage. And it makes little sense to me why that's necessary. But because you're in the middle of a rock and a hard place on this one with your HOA, I'm inclined to say that you should be allowed to go ahead and build this as you have presented it to us.
Thank you, Member Clapp. Member Cardin.
I'll just add that I'm supportive as well. I'm encouraged by the fact that the HOA is offering this accommodation. So that helps.
Thank you.
Was that in the form of a motion?
I'd be happy to make one, but I don't want to step on any toes.
I don't think you would be. It's District 4, isn't this?
No, this is District 2.
District 2. Oh, my apologies. Go ahead.
Yeah, I can make the motion that we approve BA 23030, the Mercado property.
We have a motion by Member Clapp for approval and a second by Member Cardin. Rosalie, if you please take a roll call vote.
Member Cardin,
Yes.
Member Clapp,
Yes.
Member Ward.
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 4-0.
Best of luck. Congratulations.
Thank you. Can we still have the 1 year to commence construction based on the timing of approvals and plan review and so forth? Is that a problem or?
Mr. Chairman,
Go ahead,
there's no
Jim.
ordinance requirement anymore, any longer
In the time frame?
in the timeframe. That is
Okay.
correct. Your variance approval is permanent.
Thank you very much.
Thank you for that clarification, Darren. Again, congratulations. Move on to agenda item number 6, BA 2022-035, the Harnett property. Mr. Mueller?
Chairman Loper, really quick. I'm sorry.
Yeah. Go ahead,
So,
Member Cardin.
I may be extra sensitive here, but I'm curious. I wonder if I should recuse myself from this one, and I'll just state it here on the record. I have a very close family member who lives adjacent to this property. Would that be a reason to recuse myself?
No, Mr. Peck is shaking his head no.
All right, then I'm in. Let's go.
Now you're going to have to deal with either a happy or unhappy neighbor. Good try, though. Go ahead, Mr. Mueller.
Okay, thank you, Chairman, members of the board. Case BA 2022-035, the Harnett property is in District 2, located at 8912 East Range Rider Trail in the Mesa area. Next slide, please. The proposal contains the following requests. A proposed front setback of 20 feet where 40 feet is the minimum. Proposed rear setback of 30 feet where 40 feet is the minimum. And lastly, new hillside disturbance of 1,165 square feet outside of the lot's buildable envelope. The parcel, next slide, please. The parcel is of a unique flag shape as a result of unregulated land divisions. Next slide, please. The lot is shown with the southern lot line to the left. And the shaded areas represent an access easement on the southern portion of the property and future right-of-way reservation area adjacent to the northern lot line, but not on the subject property. Next slide, please. There are non-vehicular access easements on the western and northern lot lines, negating setback impacts of additional street frontage for accessory structures. The front of the lot is considered to start at the northern terminus of the access easement, which is where the 40-foot front yard setback is assessed. The subject property is currently vacant, and the applicant is seeking the construction of a single-family residence and detached accessory structure. The applicant has worked with staff extensively to mitigate many challenges facing the parcel, such as reducing the right-of-way reservation area on the northern portion of the property, creating non-vehicular access easements to ease accessory structure setback burdens, and creating an access easement along the skinny pole portion of the lot to negate lot width issues. The location, orientation, and size of the proposed structures, however, still require the 3 variance requests. Next slide, please. Staff has not determined there to be a peculiar condition facing the property in that while hillside is present on the parcel, it is not an unusual geographical condition in this area. Further, while the hillside may shift development east, a large portion, approximately 20,000 square feet, of the lot's principal building envelope does not contain defined hillside per the zoning ordinance. The applicant has failed to demonstrate that the peculiar condition is not self-created in the line of title because the unusual shape of the parcel existed prior to the current owner taking possession of the property. If the board finds that the applicant has proven entitlement to the variance requests, staff offers the following to memorialize approval. Variance approval establishes a 20-foot south setback line or 219-24184. Variance approval establishes the 30-foot north setback line or APN 219-24184. And lastly, variance approval establishes permission for 1,165 square feet of hillside disturbance outside of the principal building envelope for APN 219-24184, unrelated to driveway or utilities. At this time, I would be happy to answer any questions that you may have.
Thank you very much. Are there any questions to staff at this time? I do have a question. They don't technically get credit for the pole portion. I'll call it the long skinny extension, the pole, and the rest of it the flag. They don't get credit for that distance, which is approximately what from the roadway?
Chairman Loper, that is correct. I believe that is about 200 feet, approximately. That's the length of that.
And that's just the way that the county that's the way the county defines front setback as it applies to a flag lot. It's not a special standard for flag lots, or there might be something different, but it's for a regular lot in a flag configuration.
Mr. Chairman, in essence, that's correct. The way we define front today is very limited.
Okay, thank you. Any other questions of staff at this time? Not, I'll go ahead and open the public hearing. Is the applicant or applicant's representative here?
Good morning, Mr. Chairman, members of the board. Pleasure to be with you here today on behalf of Gene Harnett, the property owner. My name is Ralph Pugh and my office address is in Mesa. And I want to thank the staff to begin with. We've been working on this for some time. They've been very professional and courteous and helpful. And I especially like the staff report. I learned a new word, morphology. So Joseph, thank you very much for that. You've increased my vocabulary slightly. It needed a lot of help, but that was a good one. And I understood exactly what it meant in this context. So, Mr. Chairman, if we could, on the screen is the architect's rendering of the home that we would like to build on this lot. And I'll explain to you in just a second what the peculiar circumstances are that we believe should merit the variances being requested. With respect to the outreach, we did reach out to our neighbor who is immediately adjoining us here to the south and to the east. And he had no objections. He's not here today and we didn't get anything from him, but I can avow to you that we had that conversation. If we could go to the next slide, we don't need to spend time here because you know this better than anybody. These are the findings that are required on a case of this nature. And as we think about hardship, I think in this case, it's important to realize that that can mean a hurdle or an obstacle. There's no definitive standard. There's no metric to define that. That's kind of for the board to determine in your own mind. The next slide highlights the purposes of the code, because at the end of the day, when you approve a variance, you've got to conclude that it does not do damage to the purpose of the zoning code, its intent and its integrity. And so here, part of the purpose of the code is to protect the character and stability of residential, business, and industrial areas. This is clearly a beautiful residential area in kind of Northeast Mesa, and to prevent overcrowding of land due to congestion of population. So those are just two of the purposes of the zoning code that we think our case supports and sustains. The next slide is an indicative one as it relates to the parcel and some of the unique circumstances. So this is a highly exaggerated flag lot, for lack of a better word, okay? Because the width of the pole is 113 feet, not 30 or 20 like you normally see. And the distance from the pole to the flag is 436 feet. We're talking a football field and a half here, okay? And so if the front were slightly larger, we wouldn't be here today because the front lot line is now determined to be the southern portion of the flag lot, right where you see that number 2045, right? That is the front lot for zoning purposes. So when we look at this, that's one of the peculiar circumstances. The next one is this lot has an elevation change of 75 feet. At the very front, it's 1970 in elevation. And at that corner where we're talking about there, it's 2045. So it's a highly exaggerated, elevated lot. Another highly unusual circumstance is on the northern boundary. We'll see it in another slide. There is a remnant of the age-old strip annexation. If you see those red lines running parallel to each other, that was in the days when you cities competed for land and they reached out. Mesa and Gilbert and Chandler, all the cities did that. Well, that's not allowed today. In today's statutes, you can't annex by drawing a strip like that. You have to have contiguity and depth and all kinds of requirements that aren't relevant here today. But what that causes this lot is the unfortunate circumstance that the northern boundary of the lot, the northern 10 feet, is technically in Mesa. So the county can't count that as part of the lot. If we could, then we don't need a rear yard setback because we got the extra 10 feet right there. Okay, so that's another highly unusual circumstance. And the other one is the access easement that we put on the pole portion of the lot is not only an access easement, but it precludes any construction of a building there. Why? Because it's 113 feet wide. If it were 20 or 30, we wouldn't have had to deal with that. So that's why we created that document, and we consciously knew that the flag, bottom of the flag there, would be the front yard. Now, let's talk about that for just a minute on the next slide if we can. So this represents some of the elevation changes that I was talking about on the lot. The next slide will show what we're talking about here. This slide illustrates the variances being asked for and how they fit into this circumstance. So the beige area there, now looking to your right, is north now, just so it's readable. So the large beige area is the access easement or no structures to be built declaration by the property owner. So that then that right line of that beige area becomes the southern front lot boundary. But the truth of the matter is, Mr. Chairman and members of the board, the area that you see in blue, the little triangle on the plan, that's a tiny, tiny portion of the swimming pool that extends into that front yard setback area. So the issue there is we are 436 feet back from range rider, and then we have another 20 feet, and that's where that little blue triangle then starts to encroach into what should be a 40-foot setback. We would urge the board to consider that as an unusual circumstance and to consider the purpose of a front yard setback. The purpose of the front yard setback is to have a nice streetscape, to have separation of buildings, not having buildings right on the street. Here, we've more than covered that with the distance of 436 feet plus 20 that we're asking for. On the northern edge, there's the beige strip. You see that there, that's the strip annexation area. Two things collide there. One is annexation. So therefore, we can't count our northern boundary as our property line because it's not in the county. But also is the interesting thing, as you know, the McDOT looks at every section line as an area that needs expanded right-of-way. They've reviewed this and they've realized that they don't need right-of-way on this section line because it traverses a mountain and no road's going to be built there. That annexation area ends a few lots to the west and it ends to the east at the entrance to Usury Park. So that's not going anywhere. And I'll show you an exhibit at the very end that demonstrates that. So in the rear, we're asking for a 30-foot setback instead of 40. And the only part of the building that encroaches is what you see in blue on the right-hand side of the plan. It's a small portion of the structure on the northern end of the property, which is not visible by anyone from the street or any location nearby. Then finally, the last issue has to do with disturbing hillside. And if we could go back to that same exhibit, there you go. So what's, no, the one that, let's see, sorry about that. The one that has the green. There you go. So the two pieces that you see in green are, in essence, they are hillside disturbance, but the one on the far right is hillside and a little bit of a wash that comes in there. That land is 1,100 and some square feet. It's roughly 1% of the entire lot. And while we do need to disturb that, it will be repaired with nice riprap and well done. So it's not going to be an eyesore to anyone, and it will facilitate the construction of this site. So those are, in a summary, the peculiar circumstances. It would be an unnecessary hardship. I mean, if we put money on it, I don't know how to do that today and what it would cost, but it would be expensive. That's not the issue. The issue for the moment is hardship. It is a hardship to have to go back in and redesign when, frankly, we've done this in a great, wonderful way. Our architect did a great job of melting this in to the frankly, the mountainside that exists on our east, the wash that exists to the west, and the location of the property. So if you could just go to the last couple slides, I'll be quiet here. This is an example of what I was trying to tell you. So we've represented two different home builders who have tried to develop and get approval in Mesa for the land just north of us. So the red line you see on the bottom of that exhibit, that's the northern boundary of our lot and all the other lots along Range Rider. And you can see that when Pulte Homes came in and asked us to help them, they realized no one's building a road over that area. It's mountainous and it's granite mountain. So there's an exhibit, then another home builder, if we could switch to the next one just to emphasize the fact, this is the same thing. This was another home builder who came to Mesa to propose a plan. And obviously no one is putting a road where the section line is. It just can't, it physically shouldn't be done. And no, frankly, no one needs it or wants it back there. So Mr. Chairman and members of the board, thank you for your patience with us this morning. We believe that the beautiful home that's planned on this site, the minor deviations that we're asking for in the variances, combined with the peculiarities of this site, the morphology, thanks gentlemen and ladies of the staff, lead to the conclusion for a positive approval of these variances. Thank you, Mr. Chairman.
Thank you, Mr. Pugh. Are there any questions at this time of the applicant? Hang on a second, Ralph. I have one maybe for you or maybe for Joe. So you spoke, Joe, you spoke of discussing alternatives Could you go into that a little bit? Like what you tried to look at, was it turning the house and adding, subtracting square footage or?
Chairman, yeah, so that's always something that we kind of ponder a little bit is orientation, size, location on the lot. Now, there may be engineering issues or that might not be feasible, but if just looking at the lot, you maybe tilt the house one way or another, it may fit a little better, but just.
Mr. Chairman, you want me to answer that one too, or you okay?
Yeah, please, Joe, you finished? Yeah, go ahead.
If we could go back to that front slide, the first slide with the house, that's the. So yes, that one, thank you very much. So that the home here, the pool area faces range rider. So the encroachment into the front yard setback is a portion of the pool area kind of on the left side. You can see where it's built up with a concrete wall. That's what encroaches. And as I understand it, there is an ordinance that's to be counted into part of the structure of the building. That's kind of unique here, but that's what it is. So that's the variance we're asking for there. And that's the view. To reorient the house, there's really no view to the east because there's a mountain. The north has a mountain. The view is south, right where that's headed. Thank you, Mr. Chairman.
Thank you. Any other questions of staff or Mr. Pugh at this time? All right, hang tight. We may have something for you. This is a public hearing. Is there anyone else in the audience who wishes to speak? Seeing none, David, no one online as well. I'll turn over to the board for a discussion and or a motion. This is in District 2. Do you have any comments? Member Clapp.
I have to admit that I had to read through this case probably 4 times to understand it as a layman. And it took me a while to get where the front and the back was. And there were a number of things that I had questions about. And I did talk to the staff about it. So, the fact that you've been able to work with staff to come up with solutions that would bring any changes in the ordinance down to, the front and back step back and the setback and the hillside disturbance, to me shows that you were trying to come up with a solution that works. And I had thought of the same question that was posed about the orientation, but in looking at what you have here, I can see why you don't want to orient it. I didn't realize that the view was to the south. It took a while for me to get that. And so from my perspective, what you've done here is as good as you can do to try to stay within the confines of the ordinance. And so in my mind, I believe you've met the intent of the ordinance and the ordinance is preserved. So I'll be supporting this case.
Member Cardin, did you have your hand raised? Yes,
I did. Just a couple of comments. Number one, I'm very thankful to see and no opposition here, and also that no one showed up. And I appreciate Attorney Pugh pointing that out. I also, of course, appreciate the clear presentation that was given. And after that presentation, it sure seems to me that there are, and I'm agreeing with Member Clapp, there are several reasons that there's a peculiar condition here and that the statutory requirements are met. So I would also be supportive.
Thank you. Fern, do you have any comments? All right, go ahead and entertain a motion.
Yeah, I move that we approve BA 2022035, the Hartnett property.
We have a motion for approval by Member Clapp and a second by Member Cardin. Beat you again, Fern. Rosalie, would you please take roll call vote?
Member Cardin,
Yes.
Member Clapp,
Yes.
Member Ward,
Yes, and I would just like to add, it is beautiful.
Chairman Loper.
Yes, and I would second what Fern said. It's going to be a beautiful home and a great presentation. Thank you.
Chairman, that's an approval by a vote of 4-0.
Unanimous. Congratulations to the applicant, Mr. Pugh. That was the last item on our agenda. We are adjourned. No. Okay. Oh. Oh, yeah, please. Sorry, Wayne.
I am not giving you legal advice. If any questions come up or you feel you need legal advice, we would have to put that on the agenda and do an executive session next month. I'm here to tell you about a case that involves this board that's been decided by the Court of Appeals. The case is J.D.'s River Bottom LLC versus Maricopa County. Chairman Loper and Member Ward were the only two participants in that case. Only 3 members showed up and the third member had to recuse himself. The application involved variances to allow a medical marijuana facility. How best to describe the location? It's a county island. It's pretty much where Rural Road becomes Scottsdale Road or vice versa, depending which way you're traveling. There is currently on a neighboring property a project known as Sunday Goods, if that helps you locate this. The 3 variances that were sought were: 1, because the proposal was located too close to an adult business; 2, it was located too close to a public park; and 3, it was located too close to another marijuana dispensary, that dispensary being the Sunday Goods. By a vote of 2-0, the board denied the variances. That was appealed. We moved for what's known as summary judgment, where we said to the court, if we take absolutely everything that the plaintiff says is true, they fail to meet the statutory test for a variance. And the trial court granted our motion. It was appealed to the Court of Appeals, and the Court of Appeals has affirmed that denial. Until this case, there's no case I can find in the state of Arizona that explains what the statutory test is for a county. There is a Supreme Court case from 7 or 8 years ago, Horn First, which explains what the test is in a municipality. And as the longer standing members of this board have heard from me on many occasions, there is a fundamental difference between the test in a municipality and the test in a county. The staff very often says to you that the application fails to meet the statutory test, and there's never been an explanation by a court as to what that statutory test is until the opinion in J.D.'s River Bottom. So the court focused obviously on the 2 aspects of the test, because the third aspect of the test, which is it meets or doesn't contradict the intent and purpose of the zoning ordinance, only comes into play if the board finds that the first 2 prongs of the test have been satisfied. The third prong is not an independent test, if that makes sense to you. Okay, so what the court said was that the condition has to be peculiar. And what they said was that means it can't be a condition that generally exists in the area. What they said that I think is very instructive to you is whether a condition exists on the property is a question of fact for you to determine. But whether that condition meets the test of a peculiar condition is a legal question, which as a quasi-judicial board, you also have to determine. So the mere fact that there is a condition on the property is not the end of your inquiry. You then have to decide, is that peculiar? In other words, it's not something that's common to the area. If you find that, what the court said, and I'm going to quote from it, a peculiar condition is one that arises from the physical condition of the land itself. Not the surrounding properties, not the character of the neighborhood, of the land itself, which distinguish it from other lands in the general area. In the presentation today, I believe it was Joseph who said, there's hillside here, but there's hillside on all the lots in the area. That's what the board's talking about. In JD's, they argued that there were conditions of the building that made it. The court rejected that by saying it has to be a physical condition of the land. I'll be frank, you know, I've been doing this a long, long time, and this test is not unusual to Arizona. It's very common. Usually the peculiar condition part's the easy part. It's the hardship. And we finally have a case where the court has talked to us about it. And that is, they said that the applicant failed to show unnecessary hardship, which exists when the land in question cannot yield a reasonable return absent the variance. So if the property can yield a reasonable return, that property does not suffer a hardship that would justify the granting of the variance. What happened was, AD kept arguing, we can't put a marijuana dispensary here. And the county kept arguing, yeah, but there's 143 other things you can do on the property. Literally, we counted 143 other things. And what the court said, you're basically admitted that you could do other things. There is no hardship. Because remember, the hardship has to be created by the regulations of the zoning ordinance. What they said that I just noticed I highlighted, because obviously it was good, was the court said where the ordinance equally affects all property in the same zoning classification, relief from the ordinance must come from an amendment to the zoning code and not a variance. I'll ask staff if you want, they can distribute you a copy of the decision. Needless to say, I was very happy. Not only that we won, but we got some clarification, and I'll be happy to answer any questions.
Comment or question. First off, congratulations. I know you love this stuff, but it still helps to win too. Number two, so you were saying that other properties in the area can or should not be used as a rationale for peculiar condition or hardship, or both?
Both. So for example, if I come in and say, I would like a variance to allow my side yard setback to be 3 feet, and there are 5 other guys in the area who have a 3-foot setback, that's not something that you consider. You have to focus exclusively on the physical condition of the property that's before you.
So, but it, like the hillside condition that Joe mentioned earlier for the project, you would not use that as an argument for your hardship or peculiar condition because 10 other lots are affected by a hillside?
No, obviously the applicant's going to argue that.
Right.
But you as the board, if you look at the area and see there are 10 others that are also subject to that, the way to correct the problem, if there is one with the variance, is by amending the hillside ordinance, not varying for a particular lot that has a condition that exists for the lots in the area.
I remember when they were first talking about variances in school. Darren was there with me. Don't act like you weren't.
Excuse me, but they've been talking about variances in school since 1928. So
Pretty
I think
much.
you're way younger than that.
But the thought was if you got repeated variance requests for certain items, you need to amend your ordinance. There's a problem with the ordinance and it's bearing through. With something like the county, how do you gauge a lot south of Gila Bend versus one in Paradise Valley or Far East Valley? It's difficult, and I get that. interesting. Thank you. Yeah, I'd like to get a copy of it whenever. Email's fine. And so and probably all of us.
I agree.
Nodding his head yes. But yeah, that's interesting. Does it fundamentally, like for our actions today, and you and I discussed these things before, but in our deliberations of the cases today, knowing this now, would it have fundamentally changed anything? These were all approvals, or is it more important in a denial?
The applicant must demonstrate both prongs of the test to your satisfaction. And then if the applicant has done that, must demonstrate that the granting of the variance will not negatively impact the intent and purpose of the zoning ordinance. So it's equally important for grants or denials. I can't tell you if it would have changed any of your decisions because you made the decisions. I just sat there. But this test is the basis of what it is staff tells you in their reports.
Okay.
I believe council wants you to verbalize your findings when you make.
Only because the courts will want that if I ever get challenged.
Whether that be for approval or denial, when you make motions, ideally you would verbalize the findings that back up your motion.
So on that last one, which is approved, so we're not discussing something that's going to come before us again, I don't believe. On that last one, we should have said, we believe the peculiar condition to be the shape of the lot and the hardship to be that the zoning ordinance doesn't recognize or take into account how flag lots are affected. I'm just throwing that out there. But that's what we should do, is say the peculiar condition is and the hardship is part of a motion. Ideally.
Yes, much more important on an approval if staff has found in its report that it does not meet the conditions. However, to say that the ordinance does not take into account flag lots would not satisfy what the Court of Appeals says is a hardship. If that's what you believe to be the case, then what you should do is instruct staff to look into a possible amendment to the zoning ordinance so that flag lots can be taken into consideration. You have to remember, you are a quasi-judicial body who decides a specific case in front of you. Problems with the zoning ordinance is something that has to be decided by the Board of Supervisors.
Okay. Fun stuff. Any questions of Wayne or anybody? Rick,
Yes.
you have one.
Yeah, so thank you, Chairman Loper. So are we on the record right now to where something I say could be held against me?
We are. That's why I suggested if you wanted to get into something more in the terms of legal advice, we would put an executive session on the agenda for next month where we can discuss it outside of the hearing of the public.
Well, I don't know. Okay. I don't know that that's necessary. I just had some comments but I won't make them now. I would be very interested in that, in that case. And I will say, for me, it adds some clarity. I'll also say, just to be vague, I'm not sure it would change anything I did today, but it certainly adds some clarity to what the purpose of the statute is. And I really appreciate that.
My purpose, so you understand, was to tell you what the court said.
Yep.
You digest it as you will. Anybody, there's a second case that was joined in with this case, which may cause you some confusion when you read this. Of course, as you know, Mr. Chairman, anytime any board member has a question, feel free to contact me directly and I'll be happy to discuss it. The other part of the case is kind of technical legal stuff. It involved this board, but in a totally separate case that was joined together.
A lot of words with 3 or more syllables. I'm out. So,
Well, I'm sorry, I would have changed my presentation had I known that.
Member Cardin, you probably heard Mr. Peck say that you feel free to contact him directly if you want
Yes.
to discuss something too that doesn't, if you want to bring it in front of us, feel free as well, or do an executive session.
Thank you. I did hear that, and I do have to say congratulations. And Mr. Peck, I really do appreciate the way you explained all that. I've always found your explanations to be very clear.
Yeah, and I want to echo that, Wayne. I know that you see you shake your head a lot of times, and to all of you, and I think I speak for all of us, we're very appreciative of the work you put in on this, and don't think that we just take things lightly. I do variances all over the place, and every board has its demeanor, if you will. And I've always wanted this to have a non-adversarial. Doesn't necessarily mean we rubber stamp everything, but a non-adversarial one. I think we've got that. But we don't take your opinions and your recommendations lightly and just dismiss them out the window. Craig, you had something you want to say?
I'm second guessing my decision. I agree with everything you said. Thank you.
All right. Anything else? Oh, Member Clapp, go ahead. Sorry.
I appreciate the information as well, because it did clear up some things about that particular case. I didn't have anything to do with it, but I live in an adjoining city, so I know kind of these marijuana cases and how they go. So the court opinion is very interesting, and it appears that the county has a little bit different regulations on where marijuana facilities can go than cities do. Okay, so at some point I probably should, if we have another marijuana facility case come to us, I'll welcome a discussion about that, so I'm clear as to what the regulations are. Thank you.
All right. Thank you, everyone. Definitely appreciate the time. We are adjourned.
Take care. Thanks.